Thank you, Mayor and Council. Ron Noble with the Fowler White Law Firm. I first came before you several months ago, it's been now, to recommend the execution of a plea agreement with the United States to resolve certain Clean Water Act violations that had been in ongoing enforcement action, first by the Florida Department of Environmental Protection and then from federal government officials, which you're all well aware of, and we don't need to rehash at this point. One of the collateral consequences or results of the Clean Water Act criminal conviction that's provided for in the plea agreement is a debarment or suspension proceeding that's required under the Clean Water Act for certain folks who plead guilty or otherwise convicted of certain Clean Water Act violations, of which the City of Venice falls under that category by virtue of the types of violations that were charged and the provisions of the plea agreement. The main concept of debarment and disqualification is that the federal government, in this case U.S. EPA, would list the city on its excluded party list system, referred to as the EPLS. We typically hear of the EPLS in terms of corporate defendants, corporate wrongdoers who are listed on the EPLS and then are barred from future contracting with the federal government and receiving any federal benefits through grants and sub-grants and things of that nature. Fortunately, the federal government doesn't have a real strong appetite to pursue municipalities and other local governments for debarment and listing on the EPLS. And this case, I don't believe, is any different, especially with the proactive and massive corrective actions that the city has implemented in response to the alleged violations. But with that said, the federal government also has presented to us that their hands are essentially tied when it comes to EPLS listing, and they are mandated by statute to pursue the proceedings against the City of Venice. So that really resulted in the initiation of discussions with EPA out of Atlanta and Washington, D.C. About 3 or 4 months ago. We opened a dialogue with EPA. The best interest of resolving this matter in favor of the city quickly, allow EPA to follow their statutory mandate on listing and debarment and suspension, while at the same time pursuing a goal that the city would not ultimately be listed on the EPLS. That's obviously our major goal in wrapping this matter up, the final issue. We all only traveled to Atlanta, I guess it was April of this year, for a meeting at EPA headquarters in Region 4, Atlanta. And the purpose of that meeting was for the city to make a presentation to the debarring and disqualification officials in Atlanta on the corrective actions that the city had made since entering into the plea agreement. As you're aware, at the time that the city entered into the plea agreement, the city had already made the vast majority, if not all, of the corrective actions required, including separating from city employment some of the individuals thought responsible for these alleged violations that rendered the city a defendant in a criminal Clean Water Act proceeding. We've also gone over the plea agreement provisions, which have all been implemented now, and that was really one of the main forces of the presentation that we needed to present in Atlanta. The primary requirement for the federal government to not list the city on the EPLS is for the government to render a conclusion that all corrective actions have been made to correct any underlying Clean Water Act violations. And I want to just say as an aside right now that your staff did a magnificent job in Atlanta with that effort, led by City Manager Black and City Attorney Bob Anderson, and I believe it's Chris Sherrick Chris Sherrick also attended as a technical representative. I've got to tell you, I've been on several of these trips to Atlanta. They're usually not very happy trips, but your staff did an absolutely masterful job in conveying the city's commitment and conveying the city's position to regulatory compliance, the corrective actions that have been made, and essentially leaving them with a very strong understanding that this was not a Clean Water Act violator that was going to be before them again. And I think EPA sincerely appreciated that presentation. We presented a huge volume of information to them. I won't go through that again. But at the end of the day, we needed to document to EPA that not only had all the corrective actions been timely implemented, which were going to be required under the plea agreement, but also that new programs, new protocols had been developed and put in place that would, in EPA's words, prevent recurrence of any similar type violations. And we had a very, very impressive program put together where Mr. Black was way, way ahead of the curve in preparation for this meeting, and we had a number of programs already in place and already in the works, which have since come to be incorporated into the compliance agreement that I'm going to turn to in just a minute. After we made our presentation in Atlanta, EPA took a break. They take about a 30-minute break to go huddle up and say, you know, what are we going to do with these guys? I was expecting a favorable recommendation that they would return to that from that break, and they rejoined us in the conference room, and I thought, well, you know, a good outcome of this meeting is going to be that they're going to conclude we're favorably impressed. We think you've shown the commitment. You've shown the corrective actions. We're going to talk to our bosses. We're going to talk to the bosses' bosses in Washington, D.C., and hopefully we will be able to come back at the end of the day and offer you a compliance agreement which will formally resolve the listing issue and prevent the city from being listed on the EPLS. Much to my surprise, pleasantly, they came back to the meeting, we reconvened, and they offered the compliance agreement at the meeting. And again, we've been on several of these trips, and it's the first time that I have ever seen a Clean Water Act defendant walk from that meeting with the actual compliance agreement in hand and offered to them. So again, it's just further testimony to the great job that your staff did and the preparations that were made in advance of this meeting. Now, the compliance agreement that we're going to discuss now is really an informal agreement. It is it's a negotiated agreement, and it does not have a level of formality that is associated with the plea agreement that we went through. It does not have to be taken back before a court or a federal judge. It's a negotiated settlement, and it is a agreement that is certainly binding, as is the plea agreement. And I do want to underscore that if the city elects to enter into this compliance agreement, it needs to be taken very seriously. It needs to be implemented with the same force and effect as the plea agreement was, and everything needs to be timely implemented. It has very stringent deadlines in the agreement. Fortunately, again, Mr. Black is way ahead of the curve, and he has already implemented, or well on his way to implementing, most of the requirements that are in the compliance agreement that we're going to go over. And again, in return for implementing all of these corrective action requirements and preventing recurrence requirements, what we gain in return is simply a commitment from the federal government not to list the city on the EPLS. That's important for this case because the city is certainly subject to federal grants and funding for its wastewater operations. So it not only are there other reasons that we don't want the city listed on this with other wrongdoers, but it does have a direct financial impact, certainly on utility operations. So